Hey guys, this is Attorney Walter, not Disability Resolution PA. I want to go through something that was very important to me. We're going to be actually doing two videos on this particular topic. Video one is essentially about whether or not President Biden should be pushing a particular agenda for self-defense at the federal level to try and go ahead and pull away from the states when it comes to the different state laws as to whether or not you can stand your ground, whether or not you can have a castle doctrine, or whether or not you can have a duty to retreat. And the reason I'm doing this video is that and the next video I'm going to be doing is answering specifically that. I feel that there is a problem in America with how we deal with self-defense for the retired and for the disabled. And I want to make this very clear. The entire reason I'm doing these videos is that I've seen a lot of comments about how the law applies. I've seen basically, and right now it's mostly Democrat-based, pushing the agenda of essentially saying that the law is wrong, that the law as applied was incorrect. And what's happening is that it's creating this disenchantment with judges, disenchantment with the legal system. I want to explain the different variations that exist to give you guys a better understanding from a lawyer's perspective exactly why it is the way that it is and why states have different versions of it. So let's get right into it. I don't want to waste a lot of time. Adrian Larkin, howdy. I want to go through specifically with this essentially why it's important to me in the second video. Why it's important to me is that I believe very strongly that all disabled and all retired individuals should have, without a doubt, the stand your ground law applied to them. If you are a VA that's disabled, an SSI, an SSDI that's disabled, a retired person, okay, 62 and above, I do not think that there should be a standard that's over here, and this state gets to decide, and this state gets to decide. No. It should be federal, that every retired person and disabled person in America has applied to them the stand your ground law for defense measures. Okay, that's another video. Let's go into what these are, and then I'll do another video specifically on that. All right, let's go through this real quick. Castle Doctrine versus Duty to Retreat, Understanding Self-Defense Law. This is an article, Alien Gear Holsters. I'm assuming holsters for firearms and things like that. We'll go through a few of these so you can understand it. Okay, and I see William Randall Biden needs to keep his nose out of the Rittenhouse case. I don't think he will. I mean, he's just going to do whatever he can with this stuff. But Duty to Retreat and Castle Doctrine, the laws of the land. And I'm doing this video because I was actually going to take this whole weekend off from doing any law stuff, because I do it all week at the law firm. But this is so important. This is so important that people understand this. It's so important because so many disabled people and so many retired people are afraid to own a firearm or have a knife on them to protect themselves. You don't expect a 62-year-old, a 65-year-old, a 67 or 70-year-old to be able to run away from danger that's imminent coming towards them. You don't expect that, and you shouldn't. Let's go. The laws of each state define the legally justifiable ways in which a person can defend themselves with deadly force. The two most common forms of which are called the Castle Doctrine and the Duty to Retreat. Although the Castle Doctrine isn't really used as much anymore. It's more so stand your ground versus duty to retreat. Okay? And remember, this is all about when you can defend yourself using deadly force, right? Or serious bodily harm, potential, things like that. These two types of statutes have different philosophies, though each can be distilled to a relatively simple concept. I chose this article because I thought it was written in a simple way. Bear in mind that this is not legal advice, but rather a general discussion about self-defense laws, blah, 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 so on and so forth. The Castle Doctrine is more common than duty to retreat statutes by far. The Castle Doctrine is more common than duty to retreat statutes by far. That's because the Castle Doctrine is significantly older than this duty to retreat idea. Okay, but those that live in states with the former breed of statute should still be aware of how the law works. So even though you have the protection of Castle Doctrine, you still should be aware that there are limitations to it. Here we go. Castle Doctrine. An archaic concept that comes from common law. It is super old. They're using the word archaic here not to be mean. They're using it purely as it's just really old law. We've had it since the beginning of time. The Castle Doctrine, such as it is named for the axiom that a man's home is his castle. Now, if we were to put that in current world terms, we would say a woman and a man's and a potential ex's home, X meaning gender, non-specific, home is his castle. All right? That's how we would do it in the modern day. Those similar precepts have been law in many cultures for centuries, if not millennia. The phrase itself comes from I'm not sure how to pronounce it, Simmons case, an English court decision from the 17th century. I have no idea how to pronounce that particular case name. The case itself has nothing to do with self-defense. The Sheriff of London was denied entry into a dwelling during a property recovery case in 1604. 1604, a really long time ago. The plaintiff in the case opted to sue instead of having the sheriff break down the door. The outcome of the case, recorded by Attorney General Sir Edward Coke, who may have been Shakespeare, was both that law enforcement can force entry into a dwelling under circumstances that justify doing so, but that a person's home is to him a castle or fortress, which could otherwise be defended as such. In other words, the rightful occupant of a dwelling has dominion over said dwelling and is permitted to defend him or herself inside it. The modern version of the law on the books, in some form, either by statute or by court decision, in all but the state of New Hampshire, is that a person is justified in the use of force inside their own dwelling if threatened. Some people wonder if the castle doctrine applies to apartments. It does. It's any dwelling. It could apply to a doghouse that you own that you're inside. That's a really big doghouse. Some people, that was a joke about women and men and potentially non-specific genders. Some people wonder if the castle doctrine applies to apartments. It does. In fact, the person that denies entry to the Sheriff of London in Semane's case was in fact a tenant rather than an owner. Yes, wherever you live, whatever you call your dwelling, you have a legal right to be there. While the right of a person to defend themselves in their own home is assured by law in most U.S. states, there are limitations on said law. For instance, you cannot use force in case of mere trespassing. Sometimes you can, but for this, you cannot use force in case of mere trespassing. The protection of the castle law is also limited to the residence of a person. Outside of their home, they no longer presume to be first among equals, but rather on the same legal ground as anyone else. So if you're inside your home, you have a special legal protection. Think of it as your magical bubble that's around you. And this magical bubble blesses you with the capacity to defend your home, right? Okay, it makes sense. If somebody breaks in, you should be able to use force to make sure that you're okay and that they don't do further damage to your home, yada, 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 okay? And remember, the force has to be equivalent to the danger, right? We're always looking at this. Okay, was the force this? Was the response this? Was the force this? Was the force this? That's what we always look at, okay? Okay, let's see what else. I just read some of the Walter Scott message. I don't even know what that is. Go blanking Walter on your boat. Hi. I'm not sure what that is. Howdy, Positively Cheyenne. Howdy. Okay, so, however, self-defense outside the home is often covered under the so-called stand your ground laws, which justify the use of force, even deadly force, if presented with a grave threat. Now, the stand your law is usually, or stand your ground, is usually applied in the sense of you can be outside of your house in a different area, so long as you have a legal right to have your body present in that area. You can apply that standard of, like the castle doctrine. You get that magical bubble around you and it's protecting you. And there you go. To put it a bit better, the castle doctrine only applies if a person is confronted in their home with lethal threat, right? Castle doctrine's about your home. Stand your ground is you can be anywhere, so long as you have a legal right to be there, etc. Anything less than a clear and present danger to life and limb will not necessarily make a person immune to conviction. But remember, when somebody breaks into your home, they usually have a friend, and they're usually not there to have tea with you and crumpets and biscuits and cuddles. So, keep that in mind. Additionally, it should be mentioned that just because a castle doctrine law is on the books doesn't mean that charges will never be brought. It may mean an acquittal, but there's a great deal of difference between acquittal at the end of a trial and charges never being brought in the first place. Meaning they could still charge you. You have to go through this whole thing to get them pulled off, right? Or you have to go through a full trial to show that you had, you just saw it on the news, right? So just keep that in mind, that you could still be charged. You could still go through the whole thing. It could be a summary judgment. It could be any one of these things. So additionally, it should be mentioned that, however, the castle doctrine does confer a certain amount of privilege to the rightful occupant of a dwelling, as a person is supposed to be safe from danger in their own home. Remember, so they're saying that's renters, that's somebody that's visiting you from out of town. If they have a legal right to be in that house, in that dwelling, in that apartment, even if they're just a renter, if they have a legal right to be there, then the castle doctrine will apply to them. The castle doctrine only applies in legitimate claims of self-defense. Some people think that the castle doctrine is more or less a blank check to do anything in their home. If you think anything like that, then you need to get disabused of it right now. Let's be clear about something. The castle doctrine doesn't give you the presumption of innocence if you shoot someone in your home. It's an ex post facto justification. It only applies after the event happens. Okay. Let me see if I can pull up a quick little definition of ex post facto. Let's see. An ex post facto law is one that declares someone's action to be criminal only after it was committed, a procedure forbidden by our Constitution. Ex post facto is defined as a law that makes chewing gum illegal and requires the arrest of every person who has never chewed gum, even before the law existed, would be an example of an ex post facto law. But this basically is saying in your home, it's an ex post facto justification. It only applies after the event happens, meaning like it's a defense. The thing happens and then you assert your defense. Your defense is that I did this, but I had good reason to do it. And it's after the case. And you're going to say, look, I was essentially, he was going to attack me. He had a weapon in his hand. He was much larger than me. I feared for my life. One of those situations. The Castle Doctrine is only a defense if and only if your claim of self-defense is plausible. So like, for example, if somebody was running into your home, but you had a magical safe room that couldn't be drilled through, like it was 1.5 feet of titanium, then it would not be realistic for you to push a button that would then shoot that person outside of that room and still claim self-defense, because they could not physically harm you at the level of killing you or extreme serious harm, which means that essentially if you had 1.5 feet of titanium, you're not going to drill through it. You're not going to go ahead and, basically try and peel it away or grind through it or blow it up or whatever. You couldn't do that. So the bottom line is that bad person would not be able to get to you. So in that case, the Castle Doctrine would not be a traditional defense for you because there was no way that it could get you. Now, if they were setting your whole house on fire and was going to heat you up in this room and you would die from lack of oxygen and the heat, then yeah, you could go ahead and do that. If you're that yonko who thinks, well, I pay the mortgage, so that means I can do anything I want and so on, you're going to be in for a shock if you ever say that junk in front of a judge. You're wrong. You're probably, I don't know what this is. I guess they wrote some cute little quote in here. Let's try to illustrate this with some hypothetical examples. A hypothetical man has had his garage broken into a few times. To do something about this situation, he leaves the garage door open and installs a motion detector. When someone wanders into the garage, he rushes out with a shotgun and shoots the person several times. He claims the shooting was justified under the Castle Doctrine. A hypothetical man discovers some people about to break into his house. He confronts them armed with a handgun. He shoots at them as they drive away, claiming that he was trying to shoot their tires, but the bullet strikes one of the teens in the car, killing them. The man claims the car was heading in his direction and might have been trying to run him over, thus claiming the Castle Doctrine applies since he was defending himself against a home invasion. So I don't know if you guys saw here, but the fact pattern was a hypothetical man discovers some people about to break into his house. He confronts them. So they haven't really broken in. They're about to break into the house. He confronts them armed with a handgun. He shoots at them as they drive away. Right? If they're planning to ram into his house and they're like revving the engine and they're starting to peel forward to ram into the house and he's right in front of the house where the wall is, he has the expectation that they're trying to kill him. And in that instance, he could open fire. But this wasn't that. They were driving away. They hadn't even broken in yet. A hypothetical contractor is sent by an apartment complex management staff to the wrong apartment and attempts to use the key he has been provided to open the door. The tenant, believing someone is trying to break in, retrieves a handgun and shoots the contractor in the chest. These aren't actually hypotheticals. Every one of them actually happened. The first instance is the Marcus Karma case from Missoula. Mont Karma was convicted in 2014 of murder and sentenced to 70 years in prison. The Castle Doctrine was denied early in the trial after it was found that he basically baited for a garage intruder and boasted of wanting to kill the kids that broke into his garage. Now, with that said, had he just kept that door closed and they broke in, then he might have had a better shot because essentially they moved something to commit a break at B&E, breaking and entering. The second was the case of David Peterson of Duluth, Minnesota. Peterson, according to Mankato Free Press, was convicted in 2017 of felony dangerous discharge of a firearm and sentenced to 90 days in jail. Peterson was noted throughout the trial to be racked by guilt, but maintained his belief that he was acting in self-defense. The third case is from January 30th, 2020, and occurred in High Point, North Carolina. The contractor, one Byron Castillo, right, the guy with the wrong key, was in stable condition, was improving as of February 4th, 2020. According to the Greensboro News and Record, prosecutors declined to file charges, as the belief of a forced entry was found to be reasonable and therefore is excusable under North Carolina's Castle Doctrine law. So here's the thing. And I guess if I could just do one particular thing to show you guys here what's important, this is basically it. There's no way to definitively always know all the facts when something happens. Like the whole Kyle Rittenhouse case, they had drone footage that was ironically withheld in high definition for an extended period of the case. But they had literally overseeing like the viewpoint of God looking down, right? To say, okay, here's what's going on. Here's exactly where each person was, the play-by-play. It was like football level, cinematography. So what I'm trying to say is that each of these hypotheticals, you wouldn't think they would happen, but they do happen. And that's why we have to go through this whole judicial process. The Castle Doctrine isn't what you think it is. It doesn't mean you get to do whatever you want in your home. What it does do is establish a legal protection for people who act in self-defense when they have a real basis for doing so. Just claiming Castle Doctrine will not save you from a prison cell if you act outside the bounds of the law. All right, now we're going to go over the duty to retreat, okay? In contrast to the Castle Doctrine is the duty to retreat, which is, in my opinion, moronic. Absolutely moronic. Absolutely. Oh, it's so moronic. It doesn't make any sense in reality. It's cute as a legal doctrine, but it doesn't make any sense in legal reality. Let's read through it, and I'm going to give you the very, kind of like, yeah, exactly. We told you not to run from, ban everything. Exactly. It's like somebody's about to hit you over the head with a pipe. You should offer them your firearm. It makes no sense. It's just, and it's all about geographic location and you having to magically leave it if you can, and it would be safe to do so. But has anybody ever been in a life or death situation? I have 5 or 6 times. And I got to tell you, you're not thinking about the law when this is all going on. You're purely in instinctual survival mode. Let's go through it. In contrast to the Castle Doctrine is the duty to retreat. The general principle behind duty to retreat laws is that the use of force, lethal or otherwise, is not justified until a person has made a reasonable effort to avoid confrontation, either by de-escalation or an attempt to leave the area where the threat is occurring. So this whole de-escalation thing, most people do that when somebody's trying to be hostile towards them, because most people inherently don't want to be in a life or death situation, right? When people go to fight, that's why you always see them bowing up, right? They're bowing up. What are you going to do about it? What are you going to do about it? What are you going to do about it? That's like their own little and that is a form of they're claiming they're escalating, but it's not immediate. There's time in between. Obviously, this classic, Italiano character from a 1950s film and this other classic mobster guy. What are you going to do about it, right? There's that time there where their brains are thinking and going, okay, I'm getting myself prepared. I'm getting myself prepared in case there's a problem. De-escalation. They both have the opportunity to de-escalate. Attempt to leave the area where the threat is occurring. If you start running from the person that wants to kick your butt, they're going to run after you, and they're probably going to catch you, and then they're probably going to beat your butt. So that's not a good thing. That is not a bueno. That is a terrible thing. And I mean, a lot of people will be like, oh, just run away. Just run away. Magically hop on a horse with Pegasus wings, and you'll be flying. You'll be fine. You'll be fine. You're not going to be fine. So, let's go through this. I'm not a big fan of it. I never have, but let's go through it. In other words, say a hypothetical mugger tries to rob a hypothetical man on the street, lawfully carrying a pistol in a concealed carry holster. Now, under duty to retreat laws, the man accosted by the robber can't necessarily draw and fire unless he has tried to either talk the robber down or flee the area. How moronic is that? That makes no sense whatsoever. Think about that. So there's a mugger. The mugger comes to get you. You have a concealed carry license and a properly concealed firearm. The mugger then tries to seriously harm you, take your jewels, take your wallet. And I love people who are like, well, they're just there for the money. Yeah, but how are they going to get it from you unless you give it to them? And if you give it to them, you have zero assurances that that's all they're going to take from you. They might take your body, seriously harm, or your life, which is game over, terminal, end, done. Right. We're not dealing with a good person that's, coming up to a person to mug them. We're dealing with a criminal mentality with the intent to steal. And let me tell you something. The people that are starving, they don't steal from people right on the street usually. And I mean, sure, you could always find instances where they do that. But what they'll usually do is they'll steal from houses when people aren't around. Because people that are starving, that ethically have no choice but to do a criminal act, they don't want to get into confrontations with people. They're not usually going to run up and steal somebody's jewelry. What they're usually going to do is they're going to try and steal from a house or a yard or something like that and then sell it, whether it's to a person or a pawn shop or whatever. They don't want confrontation, because if they have confrontation, a person legally carrying a firearm could end their life. They're aware of that and they don't want that. So the idea in essence is that a person has to have exhausted any other possibilities of concluding whatever is happening without resorting to violence. Okay, and that's cute. And as a doctrinal theory, it sounds good. It's like, yeah, we should try to do things to remove the potential of violence by removing ourselves from the situation. But if somebody is coming to mug you, they are not going to listen to your cute little voice with your little birdie chirps to tell them all these beautiful things about how they shouldn't come and mug you. I mean, sure, the news will show you an article about some lady who talked some thug down from shooting up a store. They'll do that, and you'll get 1 out of a million like that. But are you willing to bet your life on an anomaly? Are you willing to bet your life on an anomaly? Okay. The idea in essence is that a person has to have exhausted any other possibilities, yada, yada, yada. A person to have no other choice but to fight. If you have the ability to flee, you can't use force. Here's my problem with the ability to flee. And this is my thing. I'm going to be doing a specific video on this. The retired, the disabled. How are these? Okay, so let's take somebody with crutches. How are they going to flee? Let's take somebody with a walker. How are they going to flee? A wheelchair, special shoes, insert, braces. How are they? A cane. How are they going to flee? How are they going to flee? What, are they going to run up the stairs to get above the other person to somehow magically escape through a room and then do a Jackie Chan maneuver to get out the back? Come on. They're not going to do that. That's not even a little bit realistic. I mean, I have a very good imagination. I could make, I could make it happen. Okay, a retired person. How many 62-year-olds do you know? And that's giving the full extent of the benefit here. How many 62-year-olds do you know that could outrun a 30-year-old or a 25-year-old or a 20-year-old or an 18-year-old? How many 62-year-olds do you know have the capacity and the knees to make it a mile down the road after zigzagging through buildings to actually get away from somebody that's younger? Have you guys ever seen Men in Black? Did you ever see, Will Smith, literally run down an alien? I could not do that. The Men in Black, the alien organization that basically governs them, they wouldn't hire me because I couldn't do that. I would try. I would fail. They wouldn't hire me. I'd get a desk job, and I'm okay with that. It is what it is. Hey. All right, next thing. However, there's a significant difference between the castle doctrine and duty to retreat laws. Most notably is that duty to retreat laws are basically universal. They apply at home and at large. The castle doctrine only applies at home. All right, so duty to retreat applies everywhere. Castle doctrine applies to basically your dwelling. Stand your ground applies to everywhere. Next, duty to retreat laws impose a larger burden on the judicious use of force. A person has to not only be presented with a reasonable threat to life and limb, they have to have actively tried to resolve the situation by other means, up to and including fleeing the scene. That's right. You have to play a chess game with them. You have to suggest that maybe, you have a sit down with them, grab a pillow, hug it, sit on the couch, talk with each other about it. Feel good in the moment. In the moment of potential death, I want you to hug that pillow, because that is the solution they're looking for from this absolutely moronic doctrinal law. Let's keep reading. It gets fun. A person has to not only be presented with a reasonable threat to life and limb, they have to have actively tried to resolve the situation by other means, up to and including fleeing the scene. Moronic. Only when escape is not possible and no other means to resolve the situation without violence can a person use force. And here, let me give you an example of why this whole thing falls apart. Let me give you an example of why this whole thing falls apart. I love it. Seven God is awesome. I don't hear many stories that a horse magically shows up. Not just a horse, a Pegasus. Let's get this right. Let's make it even more rare. Let me give you an example of exactly why, why this all falls apart. Duty to retreat. There's a mugger. The mugger walks up to a woman. The woman is obviously wondering why this mugger is so close to her, right? The woman then basically has a duty to run away from this person who could potentially harm her. She's wearing heels. So then what do we do? Where do we say there was a duty to retreat? She had the capacity to run away as a human being. Let's say she was younger. She could outrun the person, but she was in heels. So what do we expect her to do? Do we expect her to break her heels off and click, clack, click, clack, click, clack her way away? Do we expect her to take one step back, pull, and shoot? Do we expect her to just give over whatever she has in her life to this person? At what point does it become outrageous? At what point does it become just stupid? To me, ab initio, the very starting point, the first element analysis, it's stupid. It's moronic. Let's take every situation. The person takes one step. They realize that they're not going to be able to run away from this person that's mugging them. They turn and shoot. Well, they've been trying to turn and step, so now they've just basically opened their back to somebody who can tackle them. It doesn't make any sense. It's never made any sense. Let's keep reading. It should also be noted that those states that have duty to retreat laws almost universally allow the use of force is justified when retreat is not possible or would pose a danger in and of itself. So these laws are not unreasonable at face value. But they kind of are. They only mandate that a person resort to nonviolent means of ending a conflict before resorting to violent ones. The only time this law makes any sense is if this person is facing somebody who's not trying to really do a criminal act to that person in the beginning. Somebody gets into a fight with somebody. The idea is you have a duty to retreat to get away from that person who's trying to have a fight with you. And they're not going to chase you down and beat you over the head and steal your wallet. Only in the least level of potential conflict does this kind of maybe make sense. But then wonder, why does the burden fall on the victim to have to get away? Should the burden not fall on the aggressor to have to then step away, which is standard ground law? Right? Okay. I just, if I were ever president, I would mandate that every single disabled person that's registered through the SSA via the SSI, SSDI, DAC, etc. programs, or a VA vet or a retired person, automatically, I don't care what state you live in, I don't care what territory you live in, automatically gets stand your ground law. Automatically. There would be no question. It would be automatic. First thing I would pass in office is exactly that. So these laws are not unreasonable, blah, blah, blah. They only mandate, the stand your ground law that have been of much concern in recent years differ from duty to retreat laws in that the use of force, even lethal force, is justifiable if a person is attacked outside the home. In other words, if attacked, you can fight back. When I grew up, if somebody hit me, I was fully authorized by my parents to beat the heck out of that other person because that was the rule of the house. If somebody attacks you, you have the right to go ahead and defend yourself. And defending yourself sometimes means incapacitating the other person. To tell me otherwise would be just to be living in a lie, right? Some castle doctrine states have a duty to retreat. As mentioned above, some castle doctrine states actually have a duty to retreat outside of the home. 12 states, in fact, impose the duty to retreat outside the home, but have a castle doctrine. By statute or decision, that covers defense of oneself within the home. All right, the following states have this: Arkansas, Colorado, Connecticut, Delaware, Hawaii, Maine, Maryland, Massachusetts, Minnesota, Nebraska, New York, New Jersey, Rhode Island. All absolute morons when it comes to the politicians that pass that. And here's why. If you have any children and you are now required to magically leave your home because somebody is intruding into the house, you are not going to leave your children there. If you have to physically get out of your house because somebody is chasing into it, you should not have a duty to leave the only sanctuary you have on earth, the only place that you know is safe, to go into another more unsafe place. For example, when somebody breaks into your home, they almost always have a buddy. It's the bottom line. If you guys are sitting there thinking criminals don't have friends that often assist them with doing criminal conduct, please look at any Hollywood movie. Ocean's 11, there were 11 of them. Ocean's 12, 13 of them. Ocean's 8, there were 8. There's always accomplices. There's always people helping make some sort of thing into a house a reality. Otherwise, it's just a brute force they broke in. If they're just a brute force and they broke in, guess what? They're not there to have crumpets. They're not there to have popovers. I mean, you know, how many women have faced disgruntled ex-husbands, boyfriends? And of course, we'll do this. How many men have faced disgruntled women, you know, exes, and then the gender X potential, you know. It doesn't make sense in a real practical application. All right, the reasonable person and self-defense law. Some have opined that duty to retreat laws bar a person from defending themselves, but is not necessarily the case. Neither is it the case that castle doctrine or standard ground self-defense laws give the average citizen more leeway than they might otherwise have to defend themselves. In some ways, perhaps, standard ground and castle doctrine laws in some states give a person immunity from civil suit should they have to defend themselves with even lethal force. However, the existence of law and what happens when a person actually does defend themselves are two different things. We're almost through, guys, and then I'll give a summary. First, the decision to charge a person with the crime involves law enforcement, local prosecutors, and or district attorneys, possibly even a grand jury. Which we just saw, whether charges are precluded from being brought depends heavily on every party involved in the legal system, rather than just how the average person interprets law. Even if a defensive shooting occurs under ostensibly the auspices of the castle doctrine or standard ground laws, the shooting must meet the test of the reasonable person. In other words, a perfectly reasonable... Whoa. That's wrong. They did something wrong in this article. A perfectly reasonable person. They should not have included perfectly. There is no perfect reasonable person. Reasonable person standard is what would a cab driver do? What would a construction worker do? That is the reasonable person standard. There is no perfectly. I want to point that out here. A perfectly reasonable person would have done the exact same thing if placed in the exact same scenario. That's inaccurate for this. It's not a perfectly reasonable. It's just a reasonable person standard. It's not perfectly. The reasonable person is an abstract construction, and whether a reasonable person would do the same thing as person X is not necessarily something that will be universally agreed upon by everyone involved in the legal system. Of course, that's why you have defense attorneys. That's why you have prosecutors. In other words, there isn't much difference in what will add up to a successful claim of self-defense. Regardless of which law is on the books, the only difference is that duty to retreat statutes mandate an attempt to be made to get out of the situation without violence first, if possible. If possible. All right, that was basically the write-up. I have some other write-ups here that I can always go through, but I want you to understand there's a problem with our legal system. The problem is that we give too much potential options to criminals intending to commit crimes. Maybe not all of them, right? They get there and then they do a heck of a lot more than they intended to. Maybe they get there and do less than they intended to. They don't end up stealing something. But when they've already broken into your home, that is something. I want you guys to think about this. And this is what I think is incredibly important. You might hate me for saying this. You might not hate me for saying this. But at the end of the day, a disabled person should not have to be thrown downward in their attempt to pull their firearm out to defend themselves. A disabled person should have enough time to make the choice as to whether or not to pull out a firearm. And if they are required to retreat, it is unreasonable to expect that they can magically get out of their house, magically pull a firearm, magically figure out what they're going to do next. And let me tell you how this normally comes down. Person A will break into the backslider door of a house, right? Person A intends to steal stuff. Person B is at the front of the house doing lookout that has a radio to person A, or does a signal, a sign, a sound, whatever. The person, so let's say the owner of the home, was not supposed to be there. But the owner of the home was there because they weren't going to work that day because they were sick. Person A is now in the house starting to collect things. Person B is watching for cars. The homeowner is now waking up realizing that somebody's in their house when they shouldn't be. Do we expect this person to, the owner, run out the front of the house, run out the back of the house, climb the stairs, jump out a window, or do we expect them to draw a firearm, maybe call the police if they have time, and deal with the situation? We expect them to survive. We expect them to live. That is why they bought the firearm, because they're not a person who is delusional about the reality of harm. The reality of harm is extreme. Guys, think about how many individuals who are disabled or retired that'll be watching this video, right? Who got injured on the job and how that injury changed their life. Now, imagine somebody breaks into your apartment, your home, your trailer, your tent, your cabin, your whatever, and how much more damage they could do to your life by being aggressive towards your body. Just a thought. Guys, I want to thank you all for partaking in this. I did not intend to make videos today, but I decided to because I was seeing so much BS. The next video I'm going to be doing is on the fourth stimulus and what's currently going on. I woke up and on my feed was these little videos about fourth stimulus coming out. It's amazing. Oh my goodness. And then I did some research, and once again, it's the same thing they always do. But anyways, guys, I'll catch up with you a little bit later. I have to go swap out some chip stuff in my phone. But other than that, have a wonderful, wonderful day. Thank you so much for being part of the live stream, and I'll catch you a little bit later. I'll be doing one more in about 10 minutes. Thanks so much. Bye-bye.